Good afternoon, everyone. Welcome to the 7th installment of ConMassCL's 2019 OSHA webinar series, Preparing for and Managing OSHA Inspections and Citations. Whether this is your first CMC webinar or your 30th, we're glad that you took time out of your day to join us, and we will do our best to make sure you get the most out of the next 75 or so minutes. My name is Erin Gelb, and I will be joined today by my colleagues Amanda Walker and Lindsay DeSalvo, both of whom will introduce themselves in a few minutes. This is always one of our favorite presentations, in part because I think preparation for anything that's important can make a world of difference in the outcome, and that's especially true when it comes to favorable outcomes for OSHA inspections. I'm sure everybody listening is familiar with the old expression, and maybe it's a tired one, that those who fail to plan, plan to fail. And while I think that is true here, I like to make a slightly different point. And for those of you that think that you or your team will rise to the occasion when OSHA knocks unexpectedly at your door, I think the reality is that you're more likely to fall back to the level of your planning and preparation, which is why it's so important to get ready now and know what you can and can't do before OSHA ever shows up. We see time and again, and I certainly see it in my practice, missed opportunities to limit the scope of an inspection, to get favorable evidence in front of OSHA during the inspection before the citations are issued, and otherwise not exercising the rights or take the steps that could have resulted in a different outcome. So with that, let's get started and get you on the path to success. Again, my name is Erin Gelb. I'm the lead ConMassCL's OSHA practice in the Midwest. I've been a management side OSHA and employment lawyer for 25 years, 22 of them here in Chicago, after starting out my career for about 3 years in St. Louis. Spent about 19 years at a large Chicago-based international law firm where I led that firm's OSHA practice before joining ConMassCL and opening our Chicago office in January of 2018. While I focus on managing inspections and contesting citations in Illinois, Wisconsin, and the upper Midwest, I've worked on OSHA matters across the country. I've also tried a number of employment cases to verdict in Indiana, Tennessee, New York, Washington, D.C., among other jurisdictions. Now I'll let Amanda introduce herself, and then Lindsay, and then we'll get started.
Great, thank you. Hi, this is Amanda Stratus Walker, and I'm a partner in the OSHA practice, and I reside in Atlanta, so I take care of the southeast portion as well as the rest of the country. I actually do quite a bit of traveling. I got my start with OSHA as a political appointee in the Bush 43 administration and served in the front office there as a special assistant to the Assistant Secretary of OSHA, and then moved over to the solicitor's office where I continued to focus on workplace safety and health issues. Since 2019, I've been out in private practice helping employers comply with the law through compliance assistance or deal with enforcement matters, as well as trade associations petitioning and rulemakings, or submitting comments in rulemaking and petitioning for variances and interpretation letters. So anything that's really OSHA related, I have been working on for the last 10 years. And that also entails litigation. Sometimes when we can't find a settlement solution, that means litigation. And so I'll turn it over to Lindsay for her introduction.
All right, good afternoon, everyone. As Amanda said, my name is Lindsay DeSalvo, and I'm an associate here at ConMassCL in the Washington, D.C. office, and I work on both OSHA and labor and employment matters. In the OSHA context, similar to Erin and Amanda, I work with them to represent employers in OSHA inspections as well as throughout the enforcement process and litigation process if citations are issued. I also work to advise employers to respond to notices of alleged hazards or other correspondence that they receive from OSHA. And then a big part of my job too is helping to develop audit programs at employer sites, safety and health audit programs, and help run those. So I will turn it back to Erin to kick us off on the presentation today.
Thanks Lindsay. As you can see from our agenda, we'll begin with a discussion of why it is so important that you prepare for the possibility of an inspection with OSHA. Then we'll spend some time reviewing what your goals should be during the inspection, and we'll talk about the rights that you have as an employer. Yes, you have rights, as well as OSHA's rights during the conduct of the inspection, as well as the rights that are afforded your employees. We'll then cover some tips and pointers, things that you should keep in mind at each stage of the inspection, and then we'll end with what you should do or what you should consider if and when you receive citations. It's certainly not over if and when you do receive them, and there are many things that we can do, and I think Amanda will dig into that towards the end of the presentation. So let's talk about the current state of enforcement, because I think that certainly informs why, again, it is so important to get ready in the event that OSHA shows up at your operation. So the regulated community, I think that's employers, expected to see some rather significant changes at the Department of Labor and OSHA when President Trump was elected. Some of you may remember that the initial presumptive nominee to take over as the Secretary of Labor was Andrew Puzder, and I think that folks generally assumed that if Mr. Puzder had been confirmed, we would have seen some fairly radical changes in implementation of the deregulation agenda that many people were expecting. When that didn't come to pass and President Trump nominated Alex Acosta, who was confirmed, we had someone who was more mainstream, and although he was more mainstream, we did still expect to see some changes. And the sorts of things that we on the management side bar expected to see were a scaling back of the heavy focus or philosophy of enforcement that we saw during the Obama administration, and some sort of balancing, whether that moved to kind of an equal approach between compliance assistance and enforcement, or more of a dramatic one to compliance assistance. Obviously, we weren't really sure, but we certainly expected some ramping up of the compliance assistance and pulling back from the enforcement. We also expected to see some pretty significant changes with respect to the internal policies, the enforcement policies and procedures that for the prior 8 years had tended to increase or inflate the amount of the penalties that were levied by the agency. And then last but not least, we expected to see some retirement of between the 9 national emphasis and then the more than 150 regional and local emphasis programs. We certainly expected to see a number of them kind of put out to pasture, if you will, or at least scaled back. The reality, for those of you that have been dealing with OSHA for the past 2.5, 3 years, I assume that many of you would agree with us, our take that that reality has been quite different. I think first off, that we've seen very little to no change in terms of the internal programs and policies that inform how OSHA conducts inspections and how they determine the amount of the penalties. We've also seen no real change with respect to the number of emphasis programs, both at the local, regional, and national level. In fact, there's been a new regional emphasis program that was launched last year that deals with fertilizer-grade ammonium nitrate, or FGAN, and anhydrous ammonium. That regional emphasis program it applies in Arkansas, Kansas, Louisiana, Missouri, Nebraska, Oklahoma, and Texas. In addition to that, we've seen OSHA has announced the new site-specific targeting program, which I will talk about in a few minutes, something that both Amanda and I have had, I think, intimate experience with SST inspections and can share some thoughts that we have with respect to those. Second, enforcement has continued in a manner, I think, consistent with what we saw during President Obama's administration. If you've participated in our other webinars, you've likely heard me or any number of my colleagues say that we're largely operating in what appears to be year 11 of President Obama's OSHA. So for example, if you look at the current slide, there were more inspections conducted by OSHA in 2017 and 2018 than in 2016, the last full year of the Obama administration. It's not a significant increase. If you look in 2017, there were 32,396 citations, which was slightly up from the 31,948 in 2016. And then again, there were 32,202 in 2018. The fact that it remained at or slightly above the prior level, I think in and of itself is a fairly significant fact. In addition to that, if you were last inspected before August of 2016 and you're listening to this webinar, you might be thinking, well, what's the big deal with a few $7,000 citations? Well, for those of you that have been paying attention or have been inspected since August 2016, you know that the penalty amounts have increased significantly after a fairly substantial increase in August of 2016 as part of the initial kind of 80% catch-up. The amount for a serious or other than serious citation, the maximum amount increased from $7,000 to $12,471. The amount, and perhaps most significantly, the amount for willful and repeats increased from $70,000 to $124,000. Those amounts have then increased in January of 2018, again in January, beginning of this year, and will continue to do so each year. So we're now over $13,260 for a serious or other than serious, and over $130,000 for willful and repeat citations. So certainly a lot more at stake when you're inspected now than if you were last inspected 4 or 5 years ago. Also notable is the increase that we've seen in the average penalty per serious violation. So in 2015, 2016, if you received a serious citation, the average amount that you could expect to be cited for would be in the neighborhood of $3,100 to $3,400. In 2017, that jumped slightly to $3,600, and then in 2018, we see that increase all the way to north of $5,000 per citation. And while this is partly due to the increased penalties that I just went over in the prior slide, we do think that this is significant nonetheless. Again, the expectation would likely have been that it would have remained closer to the level that we saw in 2016 and 2017. Perhaps most surprising, I think for many of us on the management side, really shocking, is the dramatic increase in the number of $100,000 plus penalty cases. So that's when you receive either obviously a single repeat or willful that would be north of $100,000, or a package of citations that together combine to push you into 6 figures. During the Obama administration, OSHA, as you can see from this slide, averaged 157 such citation packages per year. And in 2017, we saw a very significant increase from 154 in the last year of the Obama administration to 218 such citation packages in 2017. That number has leveled back off in 2018 to 168. But if you look at the 2-year average, that's 193 such cases per year. And I don't think that anybody, any observers probably on either side of the aisle or either side of the regulated community would have expected to see that. Part of that is due in part, I think, to the OSHA's continued focus on focusing on and issuing repeat citations. As you can see from this slide, there has been a consistent drumbeat in terms of increasing the number of repeat citations issued each year, looking all the way back to 2002, when 2.4% of the citations issued were repeats. Then when you look in the beginning of the Obama administration in 2008, it was 3.2%, and by the time President Obama left office, it was up to 5.3%. That trend continued in 2017 during the first year of the Trump administration, as it reached a high point of 5.5% of the citations issued being repeat, and it's leveled off slightly in the past year to 5.1%, yet still double what you see where it started back in 2002. And I think this really is a product of 3 significant policy initiatives that we saw during the last administration. One being the 3-year look-back period, meaning the period within which OSHA would have to find and connect the current citation to a substantially similar one was changed from three years to 5 years during the Obama administration, so meaning you now need to have a clean record for 5 years. And I've had a couple cases recently where employers were in the latter half of the fourth or the fifth year, so they were over 4 years, 6 months without something, and then something happened and OSHA came back and they got nicked with a repeat. The second one is a shift from focusing on the specific site that was the subject of the original citation to more of an enterprise focus, meaning if you have an inspection that Amanda works with you in Georgia 1 year, and then you have a similar violation that's found in Chicago or in Virginia, or not in Virginia, in a federal state out east where Lindsay is, that OSHA may piggyback one site onto the other to issue a repeat, even though it's a completely different site. The third and final focus really is one from a shift from a focus of reactive inspections, meaning they're only going to come back to your facility if something happens, if they get a complaint, if there's an accident, to more of a proactive type approach. And I'm seeing that with several clients here in Chicago. We handled this inspection, we reached a settlement agreement, and then OSHA shows up for monitoring inspections on a fairly regular basis. So it all combines, again, to emphasize the importance of preparing for those inspections so you can avoid these very costly and reputation-harming repeat or willful citations. I mentioned earlier in a couple slides ago that in addition to issuing or introducing new regional emphasis program, that OSHA reintroduced its site-specific targeting program. This was announced back in October of last year. As you can see from the slide, we've referred to it as a not-so-new enforcement tool because, again, this is something that OSHA used to use, and it had retired it for a period of time, but it's back. And certainly, I think on my initial experience, and Amanda's as well, it's back in a fairly vigorous format. So this is essentially, OSHA is now selecting employers for these site-specific targeting, these SST inspections based off of the 300A injury data that has been collected and submitted electronically under the new e-record keeping rule. And I think perhaps one of the most important things to keep in mind or to understand with respect to an SST inspection is that this is a wall-to-wall or a comprehensive inspection. If they show up, much of I think what Lindsay is going to talk about, or some of the things that Lindsay will talk about in a few minutes with respect to managing the scope of the inspection, really don't apply to an SST inspection. They're going to go wherever they largely going to go wherever they want to go and look at whatever they want to look at. And so it's particularly important if you receive a letter, a warning or advising you that you are on this list and may be subject to such an inspection, that you act now and start getting things ready, trying to look into things that could be concerns before OSHA shows up at your door. It's also important to make sure that you do indeed still fall into the scope. We've seen situations where an employer's NAICS code may have changed and they may not technically qualify for an SST inspection. It's also a good time to think about your record keeping. There may be opportunities if, for example, you have employees that are only partially at your site. They may be shifted between sites, report to different locations. There may be opportunities to if their injuries do not occur at a specific site, that perhaps they need to be recorded on another log. So you want to look at that issue as well. So with all that said, there are some recent developments for those of you that are keen political observers, have been paying attention to the news in the past couple of weeks. Some changes that many observers, or these recent developments that may prompt changes that many observers were expecting to see originally when President Trump took office. So for those of you that haven't heard, I assume most of you had, but Alex Acosta, the Secretary of Labor, has resigned. And the President has nominated Eugene Scalia, a management-side labor and employment lawyer with Gibson Dunn, to become the next Secretary of Labor. As you might guess from the name, he is the son of Antonin Scalia, the fairly well-known former Supreme Court Justice. Mr. Scalia did a prior stint at the Department of Labor as the acting Solicitor of Labor under Bush 43. I think based on the Democratic control of the Senate at the time, he was not confirmed, And I believe after about a year, he returned to the private practice of law. He will likely not be confirmed until after Labor Day, so there will be a period of time with an acting Secretary of Labor. In preparing for this webinar, I came across one editorial from, I believe it was a paper in Los Angeles, that opined that with Mr. Scalia's nomination, that President Trump has turned the Department of Labor into the Department of Employer Rights. Whether that comes to pass, we don't know. We certainly, many people are interested and going to be watching closely. What that means for OSHA obviously remains to be seen. Are we going to see this shift towards compliance assistance in the final year of this President Trump's term? Everyone's obviously, we here will be watching closely, and we'll keep everyone apprised of any changes that we see. Regardless, there will still be inspections, and you're still going to want to prepare for them. And so I will turn it over to Lindsay to get started on that.
All right, thanks, Erin. So yeah, I'm going to start the discussion on how to prepare for an OSHA inspection, and then we're going to get into the different stages of an OSHA inspection. But before we jump to that, we think it's important to frame this discussion by understanding what we see as what the main goals should be for an employer during an OSHA inspection. So this slide lays out the 4 main goals that we see. And the first, I think, is probably the one that we would consider the most important, and that is controlling the flow of information to OSHA during the inspection. And this means controlling when OSHA gets certain information, how they get information, as well as the scope of information that's shared with OSHA during the inspection process. So, OSHA comes onto site, they're going to ask for a lot of records, a lot of information, probably employee interviews, but employers do have some control about what records they produce to OSHA in response to any document requests. When in the process those are actually provided for a majority of the documents that OSHA is going to ask for, and then if there's any context necessary to be provided along with those records. In terms of employee interviews, employers also have some control about how information is conveyed to OSHA during those employee interviews. Amanda will talk a little bit about employee interviews later on in the presentation, but to a certain extent, the employer might be able to prep employees for employee interviews, and then also have some control about whether or around whether and when those interviews happen. So that is an important goal to keep in mind in sort of deciding on the strategy and interacting with OSHA and responding to their different requests. Another goal is minimizing business disruption. So in a lot of cases, an OSHA inspection is going to be really disruptive, or at least somewhat disruptive to the employer's operations. It can definitely impact the way that employees do work while OSHA is on site, and oftentimes will also require changing employee work activities. If OSHA needs to interview a certain employee, that may mean taking them off the operations for a while and substituting someone else. So it can be a challenging thing to navigate during an OSHA inspection, particularly if employees are in key roles, which they often are going to be if they're the ones that you're pulling off to maybe help with collecting documents or reviewing documents, or if they're ones that you have to pull to engage in interviews. I mean, those key employees are usually going to be, or often at least, be the ones that OSHA wants to interview. So, this having to replace certain employees or remove certain employees periodically from operations can definitely cause operations to slow down, if not periodically have to stop. Thus, we think taking proactive measures to plan out how you'll respond to an inspection beforehand is really important. Deciding who will assist in certain aspects of the inspection, making sure those employees are trained on their participation in the inspection, what role they'll play, making sure that employees know their involvement in an inspection. That can help a proactive measure to, as much as possible, minimize the disruption that takes place during an inspection. It's also important to note here, I think, that OSHA is limited in their inspection authority by the requirement under Section 8A of the OSH Act that an inspection be reasonable. So this also gives an employer some leeway in how it can respond to OSHA's requests for interviews or documents during the inspection. You know, if certain requests would substantially impact or disrupt operations, if they're asking for, you know, a crazy amount of documents, for example, and it would take multiple people to be able to review and go through them, and this could really impact operations, the employer might have the ability in that situation to push back a little bit and say, you know, that's not really reasonable based on the context of this inspection, and Section 8A gives them the ability to do that. The third goal that we think employers should have during inspection is to cast their workplace in the best possible light. So the outcome of an inspection can often be impacted by the tone of the inspection, you know, how the employer is interacting with OSHA through the inspection, as well as the perspective that OSHA gets throughout the inspection of individual programs and the employer's physical workspace. So the way that an employer can impact that is by, you know, potentially providing additional information related to written programs that are provided to OSHA to ensure that OSHA has a full understanding of the impact of that program. This could also mean, you know, devising a specific route for an inspection beforehand, making sure that OSHA is taken through as little of the facility as possible based on the scope of the inspection, so that they're only really seeing certain parts of the facility that they need to see pursuant to the reason for the inspection. And then finally, once an employer learns of an inspection or is aware that there's a chance an inspection could take place, you know, this could be in the situation where an employer just reported a serious injury to OSHA and they know that OSHA could respond to that report by conducting an on-site inspection. It should act as quickly as possible to identify hazardous or potentially hazardous conditions at the work site to the extent that it can do so. Obviously, if an employer can identify an issue before the compliance officer, that's the best possible outcome. They can address it, and hopefully it's something that's not detected by the compliance officer. But even if during the inspection, the employer sees simultaneously with the compliance officer an issue or a hazardous condition, to the extent that an employer can address it during the inspection, you know, that could give some good faith points in the compliance officer assessing, you know, whether to cite and how to cite the employer after an inspection. It could also potentially maybe avoid a citation for the issue. I mean, that's definitely not guaranteed, but, you know, something that could work in the employer's favor. Additionally, some problems that might be identified during an inspection are not actually compliance issues. So to the extent that the employer can identify those types of issues early, it can try to address those issues with the compliance officer, explain to the compliance officer why this is not actually a violation of an OSHA standard, and hopefully be able to avoid a citation being issued in the first place. And if not, and a citation is still issued related to that particular condition that was identified during the inspection, then, you know, at least the employer is at the point where they have an understanding of why this shouldn't be a compliance issue, and they can prepare to defend themselves against any such citation. So this is the language that I just kind of touched on in the last slide, Section 8A of the OSH Act. And this is important because this is the regulation that gives OSHA authority to actually conduct inspections, but it also does put a really important limitation on their ability to conduct inspections. So you'll see this is the language from the OSH Act. It says OSHA may inspect at reasonable times any workplace during regular working hours and at other reasonable times within such reasonable limits and in a reasonable manner. So the word you see repeatedly there, and the key from an employer perspective, is this concept that an inspection has to be reasonable. OSHA can't come in and just demand all of your records and shut down operations to be able to conduct its inspection. Their requests have to be reasonable, the timing of the inspection has to be reasonable, and their conduct during the inspection also has to be reasonable. So this is a really important limitation on OSHA's authority that employers should try to keep in mind during the course of an inspection. So the next few slides are going to review the rights of the different participants in an inspection. So during an inspection, OSHA has rights, the employer has rights, and employees also have rights. This first slide is going to be OSHA's inspection rights, and then we'll go through each of the other participants in an inspection as well. So as I just explained in the prior slide, OSHA does have the right to inspect workplaces under Section 8A of the OSH Act within reasonable limits. OSHA's inspection authority is also limited by the requirement that it have probable cause to inspect a facility. So this is where the warrant requirement comes in. OSHA can conduct an inspection at an employer's worksite with the consent of the employer, but OSHA must otherwise have probable cause, and if an employer doesn't consent to an inspection of its worksite, then OSHA would have to try to obtain a warrant based on probable cause to actually inspect the worksite. OSHA can get probable cause to inspect a worksite in a number of ways. It can be based off an employee complaint. So if an employee contacts OSHA and complains of a hazardous condition at the worksite, that could serve as probable cause for OSHA to conduct an inspection. A report of an injury or a serious injury or illness to OSHA could also be the basis for probable cause to conduct an inspection. You know, an injury or illness complaint could also come potentially from an emergency responder, and that could serve as the basis for an inspection. Another way is through OSHA inspection programs that target certain types of hazards or particular industries, and those are what are called like National Emphasis Program, Local Emphasis Program, the SST that Erin referred to a couple slides ago. So for example, OSHA has established a National Emphasis Program on amputations, which permits it to target inspections of employers using either certain machinery that more often leads to amputation based on the data that OSHA has, as well as employers who have experienced amputations within a certain period of time prior to the inspection. These programs, like I said, could also be local emphasis programs as well as regional emphasis programs. As long as OSHA is relying on good data for these programs and it uses it in a neutral manner to randomly conduct inspections at employer sites, that can be permissible and that will meet the requirement of probable cause. And then the last way is if a violative condition or a hazardous condition is in plain view of the compliance officer. So if the compliance officer is in a place where they're legally permitted to be, like a sidewalk, and they see a hazardous condition on a work site, that can serve as sufficient probable cause for an inspection. The area where we see this a lot is the construction industry, where a compliance officer may be driving along a public road and see someone on a roof that the compliance officer thinks is not wearing fall protection, or at least appears the compliance officer is not wearing fall protection. That can serve as sufficient basis to conduct an inspection. OSHA also has the right to conduct an inspection without any advance notice, and they actually are required to do so. They're prohibited from giving advance notice. That can be a criminal act under the OSH Act. So if an employer makes a report of a serious injury or they have knowledge that they might be on a list for a national or local emphasis program, then the employer might have some understanding that OSHA might show up to the site and conduct an inspection, but otherwise they're not going to receive advance notice because OSHA wants to get an employer during normal operations and normal operating conditions for the inspection. OSHA also has the right to inspect records, collect evidence, and conduct employee interviews during an inspection. These are all covered by OSHA's subpoena authority, which permits OSHA to require the production of relevant documents, as well as witnesses and other information that are related to the inspection. Typically, OSHA will proceed in this regard with the consent of the employer. They'll generally issue voluntary document requests or requests for witness interviews. They don't usually rely on a subpoena, but if an employer refuses to provide the documents requested or the employees that they want to interview, then OSHA can always fall back on their subpoena authority. And just as a recommendation point here, we generally do suggest voluntarily providing information requested as well as the witness interviews requested, as long as it's within the scope of the inspection, because this does allow the employer to have some control over the flow of information and what they're actually providing to OSHA in response to these requests. If an employer is dealing with a subpoena, it's going to be much more specific and direct about what they have to provide, whereas voluntary requests give the employer a little bit more discretion in what they actually turn over to OSHA. So in addition to OSHA's inspection rights, employees on an employer worksite also have rights before, during, and after an inspection. So before an inspection, an employee does have a right to file a complaint with OSHA. An employee can contact OSHA, make a complaint about a safety issue, and they have the right to do this without being discriminated or retaliated against as a result. Specifically, Section 11C of the OSH Act prohibits employers from discriminating or retaliating against an employee who exercises one of the rights protected by the Act, which includes making complaints of safety issues to OSHA. And we've actually seen the amount of whistleblower complaints rise over the last several years. So this is definitely something that an employer should keep in mind. The penalties associated with a whistleblower complaint can be substantial. They can include things like back pay to an employee. So they have the potential to be even higher than penalties associated with a serious citation that could be issued as a result of an inspection. So really important to keep that in mind. If a complaint is the basis for an inspection, we generally instruct employers not to try to figure out who made the complaint because that avoids the potential for retaliation. And if the employee were to say, hey, I was retaliated against for making this complaint, there's a strong defense there if the employer had no idea who actually made the complaint to OSHA. Employees also have the right to participate in the OSHA inspection process. This is generally done through an inspection representative. For an organized worksite, a unionized worksite, this will usually be a union representative. And where the workforce is not organized, it could be a different designated representative of the employees on site. During the Obama administration, OSHA did issue a letter of interpretation that stated that employees in a non-unionized workplace could be represented by anyone selected by the employees, including a non-representative union agent. But during the Trump administration in 2017, that letter, as well as similar guidance in the Field Operations Manual, was withdrawn. There wasn't really much guidance included with the withdrawal that really discussed the impact of the letter being withdrawn. But there's certainly now a basis to argue against the inclusion of a non-representative union agent in an inspection for a work site that is not actually unionized. And we would definitely recommend, sticking to that and taking a stand against that happening. Non-management employees have the right to a private interview during an inspection. We do take the position that this is the right of the employee, not the right of OSHA. So it's the employee's decision as to whether they want a private interview or not. That's definitely something that OSHA could push back on, but that is the position that we've taken. We think that there's a strong argument for that. And then finally, employees also have a right to participate in anything that happens after an inspection, like an informal settlement conference, as well as to have access to records associated with the enforcement action. The regulations generally require that much of that documentation be posted in the workplace, like citations or hearing notices, and those need to be posted in a conspicuous location so that employees can see them. And then finally, Employers also have rights during an inspection. We've already discussed the right to a reasonable inspection at a reasonable time. This means that an employer does have the right to push back on the scope of an inspection. Erin talked about this a little bit, but the idea that the scope of an inspection should really be limited to the reason that OSHA is at the facility for the inspection. If it is an employee complaint, then OSHA should be limited to inspecting the conditions associated with that complaint. If it's an injury, a serious injury report, they should be limited to inspecting conditions associated with that serious injury report, and employers can push back in that regard. Employers also do have the right to demand an inspection warrant because they have the right to be free in their workplace from unreasonable searches and seizures and can keep OSHA off the property under this right. I'll talk about it a little bit more in a couple slides, sort of the strategy there, but that is the right of the employer. If they want to demand a warrant, they have the right to do so. The employer also has a right to an opening conference, and we would definitely recommend that they assert that right during the inspection process. This is an opportunity for the employer to understand why OSHA is at the work site and to discuss the scope of the inspection and establish the scope of the inspection before the inspection actually gets underway. So this is definitely a right that we always promote employers to assert during an inspection. Employers also have the right to get a copy of the complaint or complaints that are the basis for the inspection. If OSHA shows up to the work site because an employee made a complaint, then the employer has a right to see that complaint. And this, again, is important to establishing what the proper scope is for the inspection. So we would definitely, encourage employers also to always get a copy of the complaint. They do have the right, when turning over information to OSHA, to protect any trade secrets and confidential business information. This doesn't mean that the employer can keep certain information from OSHA, but it does mean, that they can assert that certain things are confidential, so that if a FOIA request is ever made for the inspection file or something like that, OSHA is aware that there's certain information in there that the employer believes is confidential or trade secret, and they should at least contact the employer to discuss that information before it's just turned over to a third party. An employer has a right to have an employer representative with the compliance officer throughout an inspection. Have someone right there walking around with the compliance officer, taking side-by-side notes, directing the compliance officer through the facility for the inspection. And then there's also a right, and an important right as well, to have someone participate in management interviews with the compliance officer. Again, this is a right that is the employer's. OSHA holds employers accountable to statements that are made by their management representatives in interviews. So the employer has a right to be present to know what is said during those interviews. And so even if you have, a disgruntled manager who might not want an employer representative in the interview with them, that's the employer's right to be in there to know what's being said. And then finally, employers also have the right to participate in the closing conference as well as to challenge any citations that are issued as a result of an inspection. So before an inspection gets started, these are the things that we recommend that employers do to prepare for the possibility of an inspection. And I'll just kind of highlight a few of them right now. The first here I think is really important and really helpful, and the first two actually I think kind of go together. So the first, an employer should have an understanding of whether there are any national emphasis programs, local emphasis programs, or other compliance directives that apply to them. This kind of gives the employer a heads up that OSHA could conduct an inspection based on one of these programs. And these programs also all have directives that explain what the criteria are, what OSHA will likely ask for during the inspection. So it's a really good way to prepare for those types of inspections and know ahead of time what OSHA might do during the inspection, what they might ask for, and so you can take steps to prepare for those. Related to the criteria for those programs, We've definitely had employers who OSHA's come on site and said, we're conducting an inspection pursuant to this national emphasis program, and the employer can say, well, we don't meet the criteria for that program, so this inspection shouldn't occur. And if that's something that can be addressed right in the beginning, that could prevent the inspection from happening altogether. And then, again, related to the second one, the OSHA Field Operations Manual, this lays out what OSHA understands to be its rights during an inspection, some information on how OSHA will conduct an inspection. So again, it's just another tool to help employers prepare. And we also actually provide a tool to help employers prepare for an inspection. We call it our OSHA Inspection Toolkit. It's available on our website, and employers can use that to prepare for an inspection as well as to refer to during an inspection to remind employers of their rights as well. And then one more that I'll highlight here, designate and audit your walk-around routes. So in preparing for an inspection, again, you always want to take the route through the facility that shows the compliance officer as little as possible. It's good to have those routes prepared ahead of time and inspect the area along that route to ensure that there's nothing there that OSHA is going to see that will be problematic. A couple other points to consider here for your pre-inspection preparation: designate an inspection team. So we've laid out here what we see as being the important roles on an inspection team. You do not need to have 8 different people to fill each one of these roles, but having a couple people that can act as the spokesperson, the person who will generally interface with OSHA. Maybe that same person is going to be the walk-around representative who leads them through the facility. But it's important to designate those people ahead of time and make sure that they know what their roles will be during the inspection. And you can do that by the second bullet point here, which is training your inspection team, making sure they know what their roles are, what their rights are during an inspection, as well as who to contact. Are there certain people that you want to have involved in the inspection that they need to know to reach out to them? So this slide just shows the different stages of an inspection, and we'll get into each one of these in a little bit of detail. But I'm going to start by going through the opening conference and document production. So like I said earlier in the presentation, the opening conference is really important. We would probably consider it the most important stage of an inspection because this is what kind of kicks everything off. Usually what will occur is a compliance officer will arrive on site. They're supposed to display their credentials, and then whoever will be interfacing with them right in the beginning, whether that is a receptionist, someone else who works at the main front desk. An important recommendation or suggestion that we give employers is to make sure that that person knows who they should be contacting if OSHA comes on site. It might be a supervisor or a safety and health manager, but that person who is going to be that initial interaction with OSHA should be trained on who they should contact, and you could also provide a note that they keep at their front desk to remind them who they should be contacting if a compliance officer does come to the site and want to inspect the facility. If there's a union at the facility, then the employer needs to make sure that the employee representative is included in the inspection process if they want to be. During the opening conference, the compliance officer will explain the purpose of the inspection and why he or she is there. Again, it could be a complaint, a report of a serious injury, or one of the national emphasis programs, but the compliance officer should provide that information during the opening conference. And that information will be the source of deciding what the scope of the audit should be, or the inspection should be. And that's something that should be established with OSHA during the opening conference. If it is an employee complaint, then the employer should take advantage of the opportunity in the opening conference to explain its understanding of the scope based on that employee complaint, and should, with OSHA during the opening conference, establish the limits of the inspection based on that scope. If OSHA does refuse to limit its inspection, to the reason that it's at the site, the basis of the complaint, for example, and it attempts to assert the right to do a wall-to-wall inspection where the employer does not believe that justification exists. This may be an instance where the employer does want to go ahead and insist on a warrant instead of allowing OSHA to do a comprehensive inspection where they don't think that that's appropriate. OSHA may also request specific documents during this early point of the inspection, particularly if it's based on National Emphasis Program and they have a set of documents that they usually collect. No matter the type of inspection, OSHA will almost always ask for a copy of the employer's record-keeping logs very early on, and that is something that's required to be provided to OSHA. The law actually specifically requires that those documents be turned over within 4 hours of OSHA's request for them. So just an important thing to sort of have at the ready if an inspection occurs. And we've already largely talked a lot about these things, sort of the the issues associated with either consenting to an inspection or asking for a warrant. Generally, based on the benefits of giving consent, creating this cooperative environment usually makes the inspection easier to manage with OSHA. We suggest that an employer waive the warrant requirement and consent to an inspection after they negotiate an acceptable scope. Because, if the employer demands a warrant and OSHA has to go out and get one, this could kind of change the tone of the inspection, like I talked a little bit about in the beginning, which could have a negative impact on the employer. But if OSHA is not willing to limit the scope to the reason that it is at the worksite to conduct the inspection, that's definitely a time where the employer might want to consider telling OSHA that they need to get a warrant. And then these are just some tips that we provide for the opening conference. Again, just make sure to insist on the opening conference. Have a plan ahead of time about where the opening conference will take place and who needs to participate in the opening conference. It should be, a conference room where OSHA is not really going to have to go that far into the facility to get there, and also, where they're not going to really have the ability to observe any conditions in the facility. Make sure at this opening conference to ask for the purpose and scope of the inspection and establish the scope during the opening conference. Establish both a document production and interview protocol. This is a good chance to, kind of work things out ahead of time. Avoid OSHA maybe doing on-the-spot interviews during the walkaround by establishing a protocol in advance. And then finally, if this is going to take more than one day, arranging for daily closeout meetings so that the employer can kind of keep tabs on how the inspection is going. And then for document production, employers should always insist on written requests. This just gives them an easy way to track what is being provided to OSHA, what specifically OSHA is asking for, and then what's being provided in response, and making sure that the documents provided are responsive to what OSHA is requesting. Don't create new documents. If OSHA requests something that the employer doesn't have, then that's the response. That information isn't available. The employer should not create new documents during the inspection to respond to a document request. Do your best to make sure that documents aren't left in plain sight. If OSHA sees a document, they might request it, whereas they might not have thought of requesting it otherwise. So making sure that documents are kept maybe in the main office or wherever they're usually kept, they're not kind of left around the facility. And then before documents are provided, it is important for the employer to review them, not only for responsiveness, but if there's any attorney-client privilege over some information in the document, or whether there's any confidential information in the document, so that the document can be marked accordingly if we do think that there is confidential information present. And then just quickly here, having the written request makes it easier for employers to track all the documents that are being provided to OSHA, but it's also really important to keep a copy of all the documents that are produced. And a good way to sort of track everything is to put together a log similar to what we've provided here as an example that just shows, what information has been provided to OSHA so far, so that the employer can, again, meet that goal of controlling the flow of information that's going to OSHA. I will now turn it over to Amanda to talk about the rest of the stages of the inspection.
Thank you, Lindsay. Moving on to the next stage of the inspection is the walk-around inspection. This is where OSHA is generally going to walk out to the production floor or the dock or the location where an incident occurred. And Lindsay talked earlier about the importance of a scope, and it really comes into play here when OSHA decides to go out to see the facility. Based on the type of inspection it is, determines what OSHA gets to see. If it's an incident inspection and it's narrowly tailored to a particular piece of equipment or a particular area, the compliance officer should be directed to that particular place without getting a full overview of the entire facility. The compliance officer generally knows what an employer is doing when they take them outside and around the building, if there's another exit or door that's closer to the piece of equipment or area, versus a wall-to-wall inspection where that would be something that's under the site-specific targeting program. They get the opportunity to look at the entire facility and every nook and cranny. So really important to look at scope and the walk-around inspection, thinking about your route in advance. What are they going to see? And just as an example, I was thinking back and preparing for this, a particular incident recently, there was an incident inspection where a piece of equipment was involved, and the general manager on duty didn't think that there was any concern and walked the compliance officer through the entire facility to get to this one piece of equipment that was very close to an exit door on the other side. And through walking him through the facility, we expanded the scope of the inspection to include forklifts and exits and fall hazards. So we had a very limited scope to initially start off with regards to the incident and one piece of equipment that automatically got expanded based on visual concerns that the compliance officer witnessed when he was escorted out to the piece of equipment. So very important to pay attention to that and think about how you're going to lead the walk-around inspection. It's also very important to always accompany the COSHO. Another example, there was recently an employer who had a pretty significant explosion at their work site, and it had basically been vacated. There was individuals controlling the traffic into the facility, but once the government representatives got there to conduct their inspection, OSHA was there and a couple other agencies, they were on site by themselves. They weren't being accompanied by a representative, and I think there's always value in escorting a government entity when it comes on to the employer's property. So we'll talk more about some of the information and the importance of that in the next slide, but always a good idea to accompany the representative. Take side-by-side images. With today's cell phones, this is a lot easier, but if OSHA is taking a picture of something, encourage the employee representative to take a picture of it so that they can figure out what they are interested in. I find it particularly helpful in developing defense outlines if I have photos from the inspection to kind of piece together what is the crux of each violation. Another thing that's really important to take pictures of is any measurements that OSHA conducts. It's always very helpful to have what measurements that they have in their case file when preparing for an informal settlement conference. So pretty easy with cell phones today with photos and taking pictures, so highly encourage it. The next one, act professionally, but protect your rights, goes without saying. Certainly be professional and recognize when OSHA has a legitimate basis to pursue a subject matter or piece of equipment and accommodate. But when they don't, start asking questions. What is the basis for expanding the inspection there? And just work with the compliance officer and try to determine if they have a legitimate basis. Fix hazards identified by the COSHO but not admit violations. If you're walking around during the walk-around inspection and you identify or the compliance officer points out a guard that's missing out of a piece of equipment. Don't need to go into a story or an explanation why that is the case. In a perfect response, I see what you're saying. I will address that, and not providing much additional background is a great way to handle those things. Also, require the co-show to follow the safety rules at the facility. If this requires watching a video before they're able to go into the production area, certain PPE, OSHA should follow the same rules as any other employee or contractor has to follow when they go into a particular area. Other tips with regards to the walk-around inspection, we talked about how important it is to escort OSHA at all times. One of the key things that you gather from doing that is their thought process. Where are they going in the inspection? It really is very helpful to keep one step ahead of them throughout the process. What are they looking at? What are they asking questions about? Is it more of the chemicals? Is it have to do with the process? Just very helpful to understand where they're going and correct any inaccuracies that they might be finding or focusing in on. And it also really helps determine the direction of the inspection, if there's anything that you could supplement or send them, correct any inaccuracies. Ask for notice of sampling. Pretty easy when you're just collecting a dust sample. Usually not a lot of advance notice is required, but make sure that you have the supplies necessary to collect a side-by-side dust sample. When there's personal monitoring involved and there's lapels, I think it's always a good idea to have side-by-side sampling, and that usually requires a little bit more planning because you need to hire an industrial hygienist to be there on site and coordinate with OSHA on what their plans are for sampling. But I can't emphasize the importance of this, especially with the new silica rule that has such a low exposure level. There was a recent incident where we did side-by-side samplings. One of OSHA's samples from one of the personal lapels came slightly above the action level, but they're so far down into the exposure levels and the margin of error that we had data from our side-by-side sampling indicating that it was not above the action level. So OSHA did not pursue that. In other cases, they might come back and sample again, but it was really helpful to have our own side-by-side personal sampling. So something to really consider when that is something that's taking place on your work site. Detailed notes. A lot of times you'll have the OSHA inspection and the walk around, and then you won't hear from OSHA for 4 months, and then potentially receive citations in a couple months, and then when you're going through and trying to determine what is the issue, it's very helpful to have detailed notes regarding conversations, what the compliance officer was interested in at the site, and the pictures to get a full picture of what the basis of the citation is before you walk in to discuss it with OSHA. Ask about interviews and tasks for the next visit. Anytime OSHA's on your work site, I think it's always a good idea to have a daily closeout meeting to kind of discuss what their plans are, when are they going to come back, what other activities do they want to conduct. So that's always a valuable opportunity to get some intel from them. The other important component from a inspection perspective is the interviews that OSHA conducts that can be conducted with hourly employees and management employees. Generally, if OSHA is walking around on the floor and they're asking somebody about production or the process, I'll let that happen. But the moment they start asking about how long they've been at the company and more background information on the training that they have, I ask them to arrange an interview so that we can make sure that the employee isn't distracted by their work tasks and can answer their questions. Generally, we call that the 5-minute rule. If they stop and talk for longer than 5 minutes, it's really a good idea to organize an interview. And when you're doing interviews, pre-select an office or a conference room. This should be an area that's private, it has a closed door, doesn't have any important information up on the wall. On the blackboards, pay attention to what's written up there. I've been involved in incidents where there was information regarding the incident that OSHA was investigating and background information on it on the boards. Make sure all of that is wiped down because OSHA certainly looks around the room. Lindsay talked a little bit about voluntary versus subpoenas. The vast majority of the situations, we encourage employees to cooperate with OSHA when they've asked to interview them. Sometimes, and it's a more significant investigation involving a fatality, they will issue a subpoena regardless of cooperation. It's fairly easy for OSHA to issue a subpoena, but it's always preferable to be under the voluntary rules. Typically, when OSHA is designating an employee to interview, I tell the employee that this is a voluntary interview. The employer encourages you to cooperate, but ultimately it is your decision. In most circumstances that I can think of, the employee does move forward with that interview. That non-supervisor interview, Lindsay talked about the rights. OSHA does have this perception that they have a right to a confidential interview, but there is federal case law out there that explaining that it does belong to the employee. Usually don't really bring this up with OSHA and pursue it unless the employee really does want a representative in there and they're willing to sign a waiver of conflict. A choice of representation form is essentially what we call it. It usually gets to be a heated issue with OSHA. The compliance officer is going to have to call back to the area office, and we find it easier, and in most circumstances, unless there's a really valid reason to pursue it, we let these hourly interviews proceed without having an attorney in the room or the company attorney in the room, because we don't want to be seen as intimidating the employee or discriminating, which could come later and get you into the whistleblower territory that Lindsay talked about and the potential high fines that you could face. So supervisory interviews are different. The supervisor's knowledge can be imputed to the employer, and that's really important for the determination of violation characterization. That's what gets you into the willful category. If you had a manager who knew about the wrongdoing and didn't do anything to correct it or engaged in the activity, that can be imputed to the company. And that's really important when you have a fatality case, because when you have a willful related to a fatality, you could be in the criminal hairs. Basically, OSHA has the ability under the statute to make a criminal referral to DOJ where the company or an individual can be prosecuted under the OSH standard, or there's other tools that the DOJ uses for criminal prosecution related to workplace safety issues. So very important with regards to imputing knowledge to the employer. No impromptu management interviews. A lot of times when the inspection starts, the compliance officer wants to talk to hourly employees who might have been involved with the incident. I'm generally fine with that, but do not consent to any management interviews. Always like the opportunity to talk to the management witness before they provide the interview, and also like to participate in those interviews as well. The right belongs to the employer, not the witness, for participation. So if there is a manager who says that they do not want the attorney or the company's attorney in the room while they're being interviewed, we understand that that might be a preference, but we still have a right to be there. I have not run into that situation that I can recall, but it is the employer's right to have an employee in there, since their knowledge can be imputed and it can have very serious consequences. When preparing employees, so definitely do this with all management employees, and like to do it with as many hourly employees before they're interviewed as well. We have a checklist that we go over, and we sit down and talk to them and explain the background of the interview, how the inspection started, what OSHA's interest has been, explaining that the company is consenting to the inspection and cooperating, if that is indeed the facts, and kind of go through these. I'm just going to talk about a couple that jump out at me. The right to be recorded. A lot of times, OSHA compliance officers like to audio record the interviews. It's not my preference to have that on audio, but a lot of times OSHA compliance officers can really push back and say that, well, if you're not willing to consent, we can be back here in a week or two, and I can have a subpoena allowing me to record it. Usually at that point, I encourage the employee to consent, but one thing I do really encourage them to stay strong on is signing a statement that the compliance officer has written out. The compliance officer will sit there and take notes based on the questions and answers provided by the employee, or the questions asked and the answers provided by the employee, and at the end of the interview, turn the notepad around and ask the interviewee to review the notes and sign at the bottom. The OSHA compliance officer is not a court reporter. There's a very good chance that he has missed a word or two that could really make a difference in a statement. And so always very leery for employees to sign those statements and encourage them not to. Something to keep in mind, in a voluntary interview, they're not required to do that. If they start getting particular questions about documents, lockout, tagout procedures, or the PPE policy, or certain things like that that are required to be written down by OSHA, it's okay to ask to look at those. Nobody's expected to have every detail memorized, and that's why they're required to be written. So it's appropriate to ask for those documents, and employees shouldn't be shy to do that. And my number one rule is to either a management or a non-management employee is to tell the truth. If the employee leaves remembering one substantive fact about the preparing them from the prep meeting, that's the one that I want them to remember, is tell the truth. That is the number one rule. And the other thing that I wanted to emphasize is do not guess or speculate. A lot of times an employee will feel like they need to know the answer because OSHA is asking. But it is appropriate to say, I don't know, or I do not recall, if that is the truth, rather than answering or giving an answer that they do not know, that is not truthful. So always very important to stick with the facts and stick with what you know. Moving on to the closing conference. The closing conference can be conducted at the end of a on-site investigation, or you might get an email a couple months later indicating that the compliance officer is ready to conduct a closing conference. These are held by the compliance officer. It's part of his checklist before he sends the case on for further review before issuance of citations. And during these calls, they'll let you know what they found, anything that was of concern, anything that they plan on writing a citation for. And they give you what their recommendations are going to be to their supervisor. They communicate the standards that the employer allegedly violated. They might go into detail with regards to the alleged violation. It just really depends on the compliance officer. There's some variation there, and you get a lot of a wide scale on the amount of information you'll get out of the closing conference. Discuss possible abatement and abatement dates, and they usually do not share classification or penalty. You can certainly ask, but some compliance officers hold that information explaining that it is still under review and their final determination will be made by their supervisor. But always important to have a closing conference. There's some circumstances where we'll have an on-site inspection. There will be some follow-up, and the compliance officer will consider the meeting at the end of the on-site inspection as a closing. Especially when there's been subsequent communication, I always make clear that we would like another closing conference if that's what they're counting as the end of the on-site. And a lot of times they recognize that and provide that information. Other things to do at the closing conference is correct obvious errors or misrepresentations or misimpressions with regards to a condition or an event. Talk about any violations that might have been corrected without admitting guilt, just saying that that guard was put back on such and such a date. Request time for additional information. If there's something that OSHA has characterized as way off and they plan on issuing a citation, you can ask for additional time to provide supplemental information. You have to be aware of OSHA's 6-month statute of limitations, so if you have time and they're early in the process, I think you're likely to get that additional time and opportunity to submit information. When they're running up against the line, they need to get those out and issued before the 6 months, so they usually move ahead. If it's a really complicated issue with regards to abatement, listening during the closing conference, not providing any additional details, maybe asking what the compliance officer would be would be sufficient abatement would be a good idea. You can always ask about the citation and classifications, but like I said before, you might not get those details, and take detailed notes. Always helpful when you're trying to figure out what the substance of the violation is for when developing a defense outline and preparing to go into an informal settlement conference. Talking quickly about post-settlement strategies. What do you do once you have the citation in your hands? The citations will come. They'll give a note, the particular standard that was violated. They'll give a description of the instance they believe supports a violation, and then a penalty amount. The employer has the opportunity to pay the fine and accept the violations and do the abatement, or what they believe to be abatement. They can request a variance. I don't think this is a very realistic option during the enforcement context. You can certainly petition for a variance, but they're very hard to get, and I think even harder in the enforcement context unless you had an alternative safety measure in place that might not have been the exact prescriptive one that the regulation required, but you had an alternative that was just as safe as. Really hard to accomplish in the enforcement context. You could resolve the issues at the informal settlement conference, or file a notice of contest, where then the file is sent over to the solicitor's office, and you can still continue settlement negotiations, but technically the litigation process is starting, and concludes with a hearing if it's not been settled before. Just listing some post-citation considerations, the appropriate monetary penalty amount. OSHA has some factors that are listed in their their field operation manual that helps them calculate penalty. There's good faith if the employer has a safety and health program in place, if they don't have a previous OSHA citation history, the number of employees, various factors go into that, and you can question how they arrived at their penalty amount. There is some discretion among offices, so if penalty is of importance, always asking about how they arrived at that. If they are asking for something in abatement that you don't feel like is technically feasible or economically feasible, a guard on a particular piece of equipment, if they're asking for something to be guarded that will fundamentally alter the way that you make a particular part, that would be an issue that would need to be discussed and considered as part of the post-citation considerations. Competitive disadvantage. Is your employer or being asked to do something that others in the same industry are not required to do? Are they requiring something more rigorous of you than your competitors? Also a consideration is bidding, especially with regards to the federal government and ICENet and how the citations will impact you there. Also, what is the chance of a repeat citation based on the citation that's been issued? If it's a guarding issue and you have facilities across the country in federal jurisdictions that have very similar machines, it's a real possibility and something to look at. Dock plates is another thing if you have a lot of loading facilities and doing a lot of work on docks. So looking at what the issues are and thinking about potentially putting them under an amended standard. If there is an injury, a significant injury or fatality, the impact of civil litigation, the penalties will have on civil litigation is also something to take into consideration, and whether the penalties are going to qualify you for a program like the SBEP. When you have one willful related to a fatality or two repeats in a highly hazardous, under a highly hazardous standard, those are things that can qualify you for that, so part of the evaluation. Moving on, those are just some of the post-citation considerations, and if you find one on here that I didn't specifically mention today, happy to discuss further by email or by phone. The informal conference, there are very few instances where I don't think an informal conference is beneficial, and I can only think of about one or two instances where we passed on the informal conference and went straight to the litigation in the solicitor's office, and those were cases involving fatalities. I think there's great value in going into the informal conference. It's a great way to get additional information on the basis of the citation, kind of understand where the area director or the assistant area director is coming from. the area directors are out in the field. They deal with a variety of different cases. They might see one particular instance, and that's kind of something that they encourage all of their compliance officers to look at. And they might be going above and beyond what's technically required by the standard based on this terrible incident that happened a couple months ago in their area. So it's just a really good opportunity to better understand where OSHA's position is and to see what's in their case file. A lot of times it's a kind of a due diligence in finding out what's going on, better explain the violations, understanding the cited standard, and abatement's a perfect thing to talk about in the informal settlement conference, and also disputing the facts of the citation and presenting any defenses that might be applicable. And at the end of the informal settlement conference, there might be a informal settlement agreement that is entered into by OSHA. Does not have to go to the solicitor's office. It's usually signed by the area director or the assistant area director, and that concludes the case and modifies the citations, amends the citations, can amend the penalty, abatement dates, and that can be taken care of at the area office. If it is not taken care of at the area office, the case proceeds to the solicitor's office, and the administrative adjudicatory board overseeing that becomes OSHA. It's an independent third-party government entity. It's the Occupational Safety and Health Review Commission, and they will oversee it, and it's very much like a court context. It is a court context, an administrative court. And then you get started into the conventional proceedings, the pleadings, discovery, when the rule fund starts with regards to interrogatories and requests for admissions and requests for production, documents. Motions of practice, you get into experts, and if you have your case is an expert case, qualifying experts or filing motions to disqualify the government's expert. Ultimately, the hearing would take place before an administrative law judge. Post-hearing briefs are written and filed, and then the administrative law judge issues a decision, a written decision that comes out for review. At that point, you have a couple other opportunities to challenge it. You could petition the commission, the actual commission members, for reconsideration or file it in federal circuit court. There are two different types of mandatory settlements that OSHA requires. There's simplified and mandatory. Simplified proceedings are generally smaller cases where the penalty amount is fairly low, $30,000 or less, and there's no willful repeat violations in their small employers. This simplified proceeding limits the amount of discovery. These cases typically don't have an expert. There's no depositions, and the idea is to expedite these and get these resolved because OSHA views that there's not complicated issues. If you do end up in simplified proceeding and you don't think that your case is suited for that process, there is a way to get out of it. You petition OSHA and usually talk with the solicitor to determine and get their thoughts on getting out of it. The other type is mandatory settlement proceedings, and these are for cases that are $180,000 penalty or higher. This is where there is an administrative law judge that oversees this settlement conference where both parties come together and they try to determine if there is any middle ground before the litigation process really gets going full-blown. There can be certain exchange of information and some discovery done before this process. It's really based on the parties' agreement beforehand. The parties each have to file an ex parte position statement based on what their settlement goals are and what a settlement proposal. These meetings really, they can be very effective, and there's other meetings that are not as effective, and it has a lot to do with the ALJ, how engaged they are in the process. Some ALJs, I've heard instances of them bringing a paper and basically reading their paper all day. Other ALJs get very engaged. They do their research, know the case law, and are there to give an impartial evaluation of the facts and the case law, which can be really helpful to both parties as they try to settle the case. Cases that settlement goals that are always looked at in any sort of case, whether it's simplified proceeding or mandatory or the regular litigation process, is to eliminate the potential for repeat violations, mitigate OSHA citations in the civil wrong death case or personal injury actions, impact the citations and how the business impact, like we talked about customer relationships and having to put the information into IceNet or another company that compiles safety and health information for bidding, and avoiding SBEP in the future. So these are all settlement goals that we take into consideration and evaluate as we're moving through the settlement process. There are some additional settlement goals here. Settlement strategies. Just, I know we're well over our time, and so kind of moving ahead here. There's some settlement strategies. Kind of the main ones that we consider is the withdrawal of citations. It certainly does happen. Had it happen a couple weeks ago where OSHA withdrew all the citations that were initially issued in the informal settlement process. We sign a settlement agreement saying that both citations are deleted and the case is over. It happens, but not altogether, not as much as I would like it to happen. Modified characterization. OSHA is sometimes willing to modify a serious violation down to other than serious. It still has the same significance for purposes of repeat, but some employers like the other than serious because it's not counted the same way in the bidding process. So that's another factor that's taken care of. Eliminate duplication and modify how citations are grouped and combined. OSHA has a lot of flexibility with regards to this, but I'm not a huge fan of it because it usually leaves all of the cited standards still on the books, which creates more targets for a repeat in the future. So it is a strategy, and there are times to employ it, especially when you're trying to whittle down the penalty amount, but doesn't necessarily get the cited standard off the books. Move to alternative cited standards is something that we do quite frequently. Propose an alternative standard that we don't think will present the same level of repeat exposure, and modify violation language to make it very narrow and very specific to a particular instance, trying to limit the potential there for a repeat. Other settlement strategies, negotiate strong exculpatory language. This is something that goes into a settlement agreement, and you can also put it into an informal settlement agreement. But this is language saying that the settlement is being entered into and the parties to resolve this matter efficiently and amicably and does not impact other litigation. Usually area offices around the country have their preferred exculpatory language, but always a good idea to insert in any settlement, whether it's informal or more formal settlement that goes through the solicitor's office. In certain contexts, especially high-gravity cases, usually where you've had fatalities or you've got multiple entities involved or multiple inspections of different facilities for the same corporation, looking at enhanced and or corporate-wide abatement. That's when you agree to abate a particular hazard that was found in one facility throughout all of your facilities. So OSHA likes those, but it's certainly time-intensive, and there's certain time and place for that. Leverage with regards to penalty, up and down, usually one of the least important factors to me, but some employers consider that to be very important. Global settlements. This is when there are multiple government entities that have instigated an investigation, could be EPA, OSHA, Department of Justice, civil personal injury, and trying to get all the parties at the table and come up with one creative solution for all of the potential litigation resulting from an incident and coming to terms there. That's one additional strategy that we certainly employed in certain cases. And then union. What role does union play in this? Are they supporting and how to incorporate, if they're being vocal or want a seat at the table, how to incorporate them into the settlement terms. And I believe that concludes our webinar for today. This is a list of our other upcoming webinars. We do this once a month, and we choose a variety of topics, so I encourage you to sign up for all of the webinars or go through the list and look at ones that might be of particular interest. The other thing that I wanted to mention was we're having our second annual Process Safety Summit in Washington, D.C. this fall on October 15th and 16th. This is a subject-specific conference. It's a great opportunity for different individuals who have covered processes to come together and learn about best practices, and also to engage with the regulators. OSHA was represented there last year, as well as CSB and EPA, and talk to the individuals in the national office that are really driving some of the major changes in that policy area. And the blog. What we contribute to, we write articles, updates, and a great source to keep track of what's going on in the OSHA world.
Maybe we could try to answer a few questions now, and then to the extent that there are still some outstanding, our contact information is provided in this presentation, so you can definitely contact us.
Absolutely. I was just looking at one that came in under settlement goals. How does one eliminate potential repeat violation exposure? And that's, talking about moving well, first of all, the preferable option is getting the citation withdrawn. Depending on what the facts are, if you have an affirmative defense, such as employee misconduct, that's the first preference. Another strategy that we often employ with minimizing repeat exposure is modifying the cited standard to an alternative, something that's going to have less potential repeat exposure. So those are two ways commonly we look at it and try to work with that moving forward. With that, I don't know if there's one that you see on here, Lindsay, that you have questions or answers?
There's a question regarding a template on how employers should respond to an inspection. So we do have an OSHA inspection toolkit that is available, I believe, on our website, but if anyone would like a copy, please feel free to reach out to any of us or anyone else that you know at the firm.
I see a couple questions about responding to document requests. I think, to the extent that things are going on voluntarily, that OSHA issues requests on a voluntary basis, the employer definitely has more discretion in how they respond to the document requests. If an employer thinks that OSHA is requesting documents that is not within the scope of the inspection, they certainly have the ability and should, push back and maybe get some better understanding of why that document is being requested or what relation it has to the scope of the inspection that's been set by the employer with OSHA. And as for timing of a response to document requests, again, if this is being done on a voluntary basis, there's definitely, I think, some more leeway there to discuss with OSHA what is reasonable if they're asking for documents that will take some time to collect. Explaining that to them and letting them know approximately how long you think it will take to do so. If OSHA is being really demanding on the deadlines that they've set and you don't think that they can reach it, there is a strategy in some circumstances, I think, of telling them that they'll need to get a subpoena. But we really would recommend avoiding that where possible, because once a subpoena is issued, then it is really specific about what you have to provide, and there's not as much discretion there to control what information is given to OSHA.
Yeah, that's right. I think we heard from folks at OSHA at one of the recent conference that we attended, and their view, they tend to like it better when they go get a subpoena, because then there's no question and really very little wiggle room as far as what you can and cannot respond. So I think we all tend to agree that it's best to go with a informal written response and work with that. A few other questions I see, I think that we can address. This one we could take a long time going over. Someone asked the circumstances in which and whether an employer should not consent to an inspection and should require a warrant. I'll defer to you two, or ask you two to share your thoughts. But in my view, it's pretty rare if that you would end up in that situation. There may be some extenuating circumstances. There may be a situation where it could be something like we talked about earlier, where it turns out you're not actually covered, or they've got the wrong facility, or there's some other reasons. But for the most part, I think it's typically our advice to consent to the inspection, again, assuming they are prepared to pursue the scope that is reasonable given the reason that they're there. But that said, it's certainly something that you can discuss. with counsel and decide at the time. I think having a hard and fast rule that you're always going to request or demand a warrant is likely not a wise approach. I don't know if you all have any other thoughts on that.
Just additional commentary. How OSHA gets a warrant is not an incredibly high threshold for what they have to prove, and the likelihood that they will get one is very high. I think the fact or asking for a warrant, you're potentially ruffling the feathers of OSHA. They're going to have to do some additional work to be back to conduct the same inspection. So any, good graces, you've gone away for that. I think, there could be certain circumstances where timing is not great, and you might ask for a warrant because you know that there's going to be at least a couple days, but at very, very limited circumstances. There's been employers in the past that have had a blanket rule requiring warrants. I don't think it's a good practice, and it certainly doesn't set a favorable tone with OSHA and can take a lot of time to repair. I've worked with one of those clients that no longer does that, but that's still stuck in the back of the area director's mind that at one point the employer did request a warrant at all times, and it has taken a lot of time to change the perception with OSHA. So I think there's very limited circumstances, like Erin said, and the thresholds are low. So you have to have a really good reason, and very rarely do we run across to one of those when.
In some cases, I think that the area office, if they know that, is your protocol that they will get the warrant before they show up. And so
right.
They will
That's
show
true.
up for the first time with the warrant. And as Amanda said, you can always ask them to wait for a while. You don't need to admit them immediately. And if there is someone that you need at the inspection, whether it's counsel, whether it's your safety director, and he or she is 60, 90 minutes away. We talked earlier about reasonableness. There's a reasonable amount of time that you can ask them to wait. In some cases, depending on the reason that they're there, maybe they'd be willing to come back if you explain that the necessary people will be back this afternoon or tomorrow morning. You can kind of play that by ear. So I think it's just something else to keep in mind. I see also that there are several questions about the use of drones in inspections. Amanda referenced our OSHA blog, the OSHA Defense Report. There is an article, a pretty comprehensive article on the blog about the use of drones in inspections. Just as a very, very, very brief summary of it, essentially they have started using them. There is a memo that has been issued that governs the use of drones in inspections. The key takeaway, at least at this point, and I have a feeling that it may change at some point in the future, OSHA is required to provide you with advance notice of their intent to use a drone and obtain your authorization to do so. Can they use them in public spaces to get near a site as opposed to fly over it? That's another issue. But it is something that they're using. I have not. I had a request in a fatality inspection that I was managing that OSHA wanted to use a drone. We went through the process with them. We authorized it, and then when they showed up, they decided not to. Their explanation was simply that it was too much work, too many hoops to go through, and they decided not to do it.
One of the other things I see a lot of questions regarding complaint-based inspections. A variety of different people can file a complaint. Depending on who files the complaint, OSHA gives more credibility or more weight to certain complainants, with the highest priority being a current employee. Sometimes they're former employees. Can be somebody not associated with the employer. So OSHA does take that into account, how they are related to the work site, but they do have the authority to pursue an inspection based on any one of those. The employer does have a right to get a copy of the complaint. The complaint will come to you on an OSHA form where they have basically taken the information either that was relayed to OSHA verbally or in writing and put it in a nondescript way in a form. The employee's name is not on it. And OSHA typically does not interview. They can interview the complainant, but they don't automatically interview them. But they do follow up with them and have background conversations. After they've conducted inspections, they might go back to verify the information that they've received from the employer is accurate or consistent with what the complainant said or believes. is the case.
And just to piggyback off that, you know, a complaint is a very common way that we see for the basis of an OSHA inspection. But again, you know, OSHA has the ability to conduct an inspection based on a serious injury report, and there's some guidance on that on OSHA's website at osha.gov, as well as pursuant to a national emphasis program or a local emphasis program, which are also available for review on osha.gov. So there are several different ways or bases for which OSHA can justify its ability to conduct an inspection.
And obviously, your self-reporting of hospitalizations and amputations is one of the primary triggers of an inspection. And I'll plug the blog again. Lindsay put together a masterful overview of those issues. So I think it was back in 2017, Lindsay. So I highly commend that to folks that have questions, because while you certainly want to make sure you don't get a failure to report citation, there are also many instances where you may not have to make a report, which could obviously mean that you're not going to receive an inspection. I do see a question from a friend who's asked about the use of videos or turning them over to OSHA if you have a video of the injury. What I can tell you, and I think in that experience, yes, we typically turn them over, and if you don't, that you can certainly expect certainly a written request, and if you refuse to comply with that, I would fully expect a subpoena demanding turning over the videos. So it is something that we typically turn over. And I will just add one more comment in response to a question I see towards the end. Somebody asked if it's, you know, if obtaining general advice and counsel is sufficient for most of the inspection, or if it's recommended to bring in expertise such as our firm early. Obviously, every situation varies. I always encourage clients to pick up the phone, give us a call. We can walk through things. It doesn't mean that we need to be on site and you know, working around the clock for an inspection. It could be that we can help you navigate and determine the scope early on with a few phone calls. If it's a more significant one, we may be on the phone longer, or maybe we are on site. But I think checking in and working with counsel throughout the process is a great way to obtain a more favorable outcome, and certainly getting counsel involved. I think, Amanda, you talked about that the citations you had withdrawn recently. You know, marshaling that evidence during the inspection is a way to avoid citations in the first point, and then getting counsel involved once you get the citations before you go to that informal conference to develop a strategy is a great way to get some improved results, hopefully.
Great. And with that, our webinar today is concluded. Thank you.
Thank you.
Thank you.